Well, we have Gingras vlogging once again, as always, never stops. And so we are going to look into what is he blogging about, because I guarantee you it's some stupidity. I'm the loud little ducky. Let's jump in. So first up, let's go over Judge Mata's ruling that was on 7/18/2024, which is 7/17/2024, which is the motion to vacate judgment, motion for new trial, alternatively, motion to alter/amend judgment, motion for leave to exceed page limits, filed on July 12th, 2024. It is ordered the motion is denied. So she denied everything, and which most judges would, especially when you try to accuse them of all that stuff. I mean, we see it in a lot of cases. Most of the time, the judges aren't like, yeah, sure, I'll just remove myself and change everything because you said so. So this is very common. Doesn't mean he's going to stop. It just means she denied it, and she can. So here is the first part of his blog. He's got a free speech zone. Owens v. Clayton Echard, Into the Void. He's so clever with his titles. July 18th, 2024 is when he wrote this. And Gingras isn't always about free speech. He acts like he is. He just doesn't like it when people have free speech towards him and point out his wrongs. You won't believe this. No, really, you won't. But I do not want to blog about Owens v. Echard anymore. At least not at this current phase. I have better things to do, and the case isn't at a place where there's much important new stuff to discuss. That will come later, probably, but not now. On the other hand, with so much inaccurate information being spread every day by the JFC cult, this puts me in a difficult position. Do I ignore the BS, as I've tried to do since last month, or do I respond and try to set things straight? Well, you don't always set things straight, and you start off with false information about a cult. So, yeah. But let's see what you have to say. Because I do believe you want to blog about this. Because why else would you write about it? I know the JFC cult hates me with a white-hot passion, but you can't deny that recently happened with the notice of change of judge. At least some of the less extreme JFC fanatics stopped for a moment, looked at the facts, and realized, Jesus, Gingras has a valid point we can't refute. Don't deny it. You did. You know what? We did stop and think. And then we researched. And we looked at whether it was harmful or harmless about your point. Because we are going to look at the facts and parse them out. So excuse us while some of us have to take a moment to look into it, because you could possibly have a valid point at one point. I haven't really seen one yet, but one day you could, because clocks right twice a day. So even though it is really, really, really hard to change the minds of people who made up their minds months ago, and even though I have seriously enjoyed not talking about this case, there is still a glimmer of hope. Not for y'all. There is still a small chance that some people might stop drinking Clayton's Kool-Aid, even just for a minute, and they may finally realize the truth, that there are serious problems in the way this case has been handled, and those issues deserve public attention, concern, and perhaps corrective action. The only person that needs corrective action is you, Gingras. Nobody else in this case. Woodnick has been transparent, and Judge Mata made her ruling on a bunch of facts against your client and all her lies. And you can try to spin it in whatever way to make yourself money and continue working on this case, but just because you're trying to spin it and make yourself believe it doesn't mean it's true. Okay, so basically I have two options. One, allow the JFC cult one-sided and often incorrect narrative to be the only public commentary, or two, when important issues arise, offer my own comments to explain my views about legal rules, procedures, etc. Except for your views aren't really correct half the time. Like, you remind me of fake Christians who try to spin Bible verses into something they're not. Like, there's this one person, as a family vlogger, who has spun Bible verses into thinking that Frozen, the Disney movie, is a form of black magic and Satan and the devil, and would never expose her child to Frozen because that's magic and we don't live in that. Because a child won't figure out that it's make-believe and they can't just magically make things happen. That's the person you remind me of. Trying to spin things in a way, but just because you spin it that way doesn't make it correct. I don't love either option, but I think the harm that comes from option one requires me to go with option two. Okay, go on. You can do whatever you want. Doesn't mean it's smart. With that said, here's the deal. Earlier today, Judge Mata issued a one-line order, which we know you love. We know you love those one-line orders, denying all my post-trial motions to vacate the judgment, motion for a new trial, etc. Is that a big win for Clayton? Obviously, JFC thinks so, but here's why they're wrong. Some may think that. Pretty much knew it was going to get denied. And that's why I said at the beginning of this video, she can deny it. That doesn't mean Gingras is going to stop. It doesn't mean that he's not going to have these for appeal, because he's saving all of this stuff and documenting it for appeal purposes. It doesn't mean that one day another judge won't look at it. It just means that Mata denied the motions. That's plain and simple. That's what happened. First, as everyone knows, on July 8th, 2024, I filed a notice of change of judge for cause. That notice was based on Rule 6.1 of the Rules of Family Law Procedure, which allows any party to ask for a new judge when grounds exist. In this case, we argued Judge Mata was biased and that she had acted improperly for reasons explained in the notice. And your reasons are all speculation, not based in facts, truth, evidence, proof, nothing. So I don't think it's going to go anywhere because you don't have anything to back up your speculation, because it's just that. I understand most people following this case are not lawyers, and that's fine. But at the same time, if you are not currently licensed to practice law in Arizona, and if you do not like substantial experience practicing civil litigation in Arizona trial and appellate courts, you really need to be careful about rushing to judgment regarding what you think the law says. Although I do not follow this case closely on social media, really? Because you post a lot about it. When I do see comments, mostly forwarded by Laura and others, easily 90% of the JFC comment about the law are simply dead wrong. Well, there's a lot of lawyers who do make comments about it, and some of the people are getting their thoughts based on the comments of lawyers. I get the JFC doesn't care about the truth. No, that is what we do care about. We do care about the truth. I also get that JFC is allowed to claim that I don't know the law. That's why we have courts to settle these disputes. Yes, exactly. And we have judges. But when you don't like what a judge has to say, just like any lawyer, You go and fight it in an appeal and cry about things, or the bias, the judge didn't like me, all of this stuff. But you're making crazy claims and stating them in unethical, crazy ways. So he says, but here's the deal. JFC wants to fight this battle in social media, not in court. And JFC thinks the order today is a win for Clayton. That's absolutely wrong as a matter of law. Okay. First, the order today is void. Okay, because you can void what a judge says. But, okay, continue on. That means it literally doesn't exist because Mata had no authority to issue this order while the notice of change of judge remains unresolved. And no, the notice has not been denied as of yet. Well, Mata has denied it. So then if she stays on the case, she's already denied these motions. And if she hasn't, if she's not going to be the judge on the case, then they can give their judgment or ruling on those things. But if Mata stays on the case, which I think she will, she's already ruled in this matter and it can be put to bed when all of this is done with and Gingras is done throwing his fit. That conclusion is based in part on the text of Family Law Rule 6.1A3, which explains the procedure once a notice of change of judge is filed. 3. On filing of the affidavit for cause, the named judge should proceed no further in the action except to make such temporary orders as are necessary to prevent immediate irreparable harm from occurring before the request is decided and the action transferred. However, if the named judge is the only judge in the county, that judge may also perform the functions of the presiding judge. Okay, like I said, she denied it. And that will either stick or it won't stick. Got that? This shouldn't be hard to understand. The judge assigned to your case is biased and unwilling to follow the law. You have legal right to ask the presiding judge, Mata's boss, to look at the situation and determine if you are entitled to a new judge. While that request is pending, the case placed on hold. The rule says while the notice is pending, the named judge, Mata, should proceed no further in the action. The only exception is to make temporary orders to prevent irreparable harm. Obviously, that expectation doesn't apply here, so once again, Mata has ignored the rules and done something she had no right to do. Okay, she still did it. I know many judges who do. And her thinking is if there is a new judge that wants to overrule that, then they can. If she couldn't make the ruling. But if she ends up being able to make the ruling, she has already made it. And she doesn't have to make it again. So what happens next? What happens when a judge ignores the law and continues to make rulings in the case after a notice is filed? Well, believe it or not, that does happen sometimes. I just said that it did. Arizona courts have been clear. Any action taken by notice judge after the notice is filed is void. It is well settled that when an affidavit of bias and prejudice is timely filed, the judge has no discretion to do anything further in the case except to transfer the case to another division. We don't know that this was timely filed because when you think you are trying to say you found out about certain things and when you actually found out about things, it's past the 20 days. So yeah. West v. Superior Court, 1968. Since he had no jurisdiction to do other than transfer the preliminary injunction proceedings to another judge, the order granting the preliminary injunction was void. Okay, well that's something that isn't pertaining to this case. Itasca State Bank v. Superior Court, 1968. In Arizona, like most states, when a judge issues a void order, The order is literally treated as if it doesn't exist. Based on this, today's order denying our request for a new trial, etc., is void and thus has zero legal effect. So that's something from 1968. There might be something else that's more current that talks about this situation. This one might pertain to the case. But like I said in the beginning, she just ruled on it. Whether it means something or it doesn't mean, it just means Mata issued a ruling on what she thought, and she denied the things. And if somebody wants to come in and also deny or just say, nope, no new judge, no new trial, Mata is going to make that ruling anyways. So really, there's no harm done here. But there's also a second problem. Today's order is not signed. It is what we call in Arizona an unsigned minute entry order. Why does that matter? It matters because in Arizona, and again, virtually every court I've practiced in uses the same rule. Undersigned orders aren't final. That makes them very different from a signed order. Here's why you can only appeal final orders from the court. Okay, so if it is not a final order, why are you giving all that mumbo jumbo in your first argument? That she can't make any rulings and all that other stuff because it's on pause and all that other stuff. If it's not even a final order, then why does any of that other crap matter? It doesn't. Again, if you're not a lawyer, this may sound crazy, but while a case is pending, the judge may issue lots of different orders. Orders granting, denying discovery, orders extending deadlines, orders setting hearing dates, orders dismissing parties or claims, orders denying or requests to dismiss parties or claims. The list is basically endless. Yet we didn't need you to name all these things. The law, however, is crystal clear. With only a tiny handful of exceptions, most orders issued in the middle of a case do not qualify as final. Under the rules, to be considered final, an order must terminate the entire case as to all claims, issues, and parties, and the order must be signed by the judge. If anything is left unresolved, or if the order isn't signed, then any order issued by the court is not considered final. So maybe she's just letting you know that once somebody said she's not a biased judge, that's what her order is going to be, so just be expecting it. Maybe that's her version of a heads up for you. Oh, and to help make things even more confusing, the rules do allow a judge to issue something called a partial final order or a partial final judgment. The post-trial ruling on June 17, 2024 was a partial final judgment. But to qualify as a partial final judgment/order, the decision is required to contain very specific language and findings. Any order that doesn't contain such language is deemed non-final and thus non-appealable. Okay. So maybe this isn't going to be an appealable issue. I mean, you can try to appeal it. Everything can be an appealable issue. Just doesn't mean that it's going to be successful. And you're like, oh, to make things more confusing, but in the paragraph above, you're like, law is crystal clear. Which is it? It can be both. It can be both. It's crystal clear in certain things, and it's very confusing and not crystal clear in other parts of the law. That's why there are amendments to laws. There are new laws added, because there are situations that exist out there that haven't made it into a law. Like the law about somebody bringing a paternity matter needs to be amended to where the person has to have definitive proof before they file a paternity suit. Just saying. The law is not crystal clear on that, and that's why we're in this scenario. So what is the point of all of this? I would like to know. While putting aside the fact that it's otherwise void, the order issued today is not signed, nor does it meet the requirements of a partial final judgment. Therefore, even if the order wasn't void, which it is, it would almost certainly not be appealable. That means the order is just kind of an odd, meaningless nullity. As a practical matter, it's exactly like this order never existed at all. But again, don't take my word for it. Here's what the Arizona Court of Appeals said in a similar decision issued earlier this month. We lack jurisdiction to consider husband's appeal from the order awarding attorney's fees to the wife. The second amended notice of appeal lists the signed minute entry dated April 28, 2023. There is no such signed order. The record includes an unsigned minute entry order dated April 28, 2023, filed May 1, 2023. This order does not state the fee award amount, nor does it comply with Rule 78B. Thus, it is not a final appealable order. Okay, great. That's on awarding attorney's fees, which should be in a final order. Maybe, I don't know because I am not an attorney, does denying motions have to be signed? Or is it kind of like e-signed once the judge submits it and files it with the clerk? Maybe not. I'm just saying. Because I don't know if I've seen any of her motion orders signed. So are they all null and void? Husband also filed a separate notice of appeal when the Superior Court later awarded wife $3,552 in fees and costs in a signed order with Rule 78B language. We dismissed husband's appeal from the attorney's fees judgment, finding entry of Rule 78B judgment was improper. See Kim Vanis Monsuri, which is a case from 2007 in the appellate courts. As a result, we dismissed the appeal from the order awarding attorney's fees to the wife for lack of jurisdiction. Okay, well, I don't know if we have lack of jurisdiction here, but that was awarding attorney's fees, which is part of a final order, is how I would look at that. I am not trained in law, but I don't know if every motion and denial of motion has to be signed. And if anybody knows if all the previous motions have actually been signed by her and this one just isn't, let me know in the comments, because I would like to hear more about this. Because not only are we here to learn about the case, we are here to expand our knowledge on cases, on becoming better people, our moral and our ethics, learning about law, and different things that we are all commonly interested in. So if you know something about this stuff, let us know so we can once again expand our knowledge. Constantine v. Constantine, which is July 9th, 2024. Okay, got all that straight, folks? Let me just break it down as simply as I can. You're not Barney. Barney at least was cute. You are not. 1. The order today is void because it was issued by a judge who is subject to an unresolved notice of change of judge for cause. Because the order is void, it has no legal effect. Okay. Great. The order is unsigned and therefore non-final. Why does that matter? It matters for 2 reasons. First, because you can't appeal non-final orders. And second, Laura's time to appeal does not begin running out until the court issues a final signed order. That comes straight from Rule 9E1 of the Arizona Rules of Civil Appellate Procedure, which states, if a party timely and properly files the Superior Court clerk of any of the following motions, the time to file a notice of appeal or cross appeal for all parties begins to run from the entry by the Superior Court clerk of a signed written order disposing the last such remaining motion. That's also the same issue discussed in the Constantine case mentioned above. You can't appeal unsigned minute entry orders because they are not final. Okay, great. Like, I don't know how many in the JFC crew were like, oh my God, that's such a big win for Clayton. Like, she denied this. When everybody knew it was going to be sent to another judge. I was just like, okay, she denied it. I wasn't even going to cover it because it's not that big of a deal that she did it. So, I mean, it isn't final, but she listed that. I mean, you've seen if you've followed any of like the Young Thug RICO trial that's been happening, the judge, there was motions for dismissal, motion for mistrial, recusal, all that. The judge that was on that case, Glanville, denied all of those. He now has since been removed because of other motions that were assigned to other people and things like that, but he still issued his rulings on those. So, yeah, if it's going to be sent to another judge, it's going to. And once that comes out, when all this is over with, before we even get to the appeal part, because they're still doing stuff before the appeal, which I hope doesn't screw up their appeal. I wouldn't think that Gingras would allow that to be screwed up. Because I don't think he's that incompetent. But it is what it is. Because the unsigned order is non-final, Laura's time to appeal has not started running yet. Per Rule 9E1, Laura has 30 days to appeal from the entry of signed written order disposing of her post-trial motions. We don't have a signed order yet, so the clock hasn't started ticking. This is if you actually submitted this in a timely manner, which you may not have done. And the other judge can come back and say, this wasn't submitted in a timely manner because you found about this on June 10th. And you filed it later than 20 days. You wasted your time writing an email instead of filing stuff. 4. Like virtually everything else in law, there is a narrow exception that might permit but not require Laura to appeal the undersigned order immediately, even though today's order is non-appealable on its face. This post is long enough already, but if you really want to become an expert on obscure issues of appellate jurisdiction, read this. Barassi v. Madison, which is a Arizona 1981 case. Finding premature notice of appeal from non-final order was okay because dismissal of the present appeal would punish the appellant for being too diligent. Well, I don't think that you've been too diligent or diligent. I believe you've just had deception and lies and skirting the truth. I don't think this exception applies here because there are too many other unresolved issues hanging out there, such as the notice of change of judge plus the amount of fees. Yes, that is unresolved because things have been submitted by the correct date, and then she still has to issue that, which she shouldn't be able to issue right now, right? Because you're asking for a change of judge. So that order in your mind, signed or unsigned, would be null and void as well. 5, all else aside, the issue of whether we get a new judge remains unresolved as of today. The presiding judge may still grant our notice in your dreams, in which case the matter will be assigned to a new judge, or she may deny the notice, in which case we will immediately appeal. Great, do that. Stop blogging about it. You don't have to sit here and listen to the ramblings of people that do not like Owens. You know how you could show us in a professional way? Is by doing it in court and not doing unethical behavior, calling people names, wishing their death, wishing their homelessness and all of that. Like, you could just show us by doing things in court. You don't have to be out here yapping your gap. Six, if Judge Fisk removes Mata from the case, this creates a real procedural mess because it means the new judge technically won't be able to consider the arguments raised in the post-trial motions to vacate, etc., since those motions have already been denied. I assume that is exactly why Mata issued the decision today, purely to try and block Laura from having a new judge correct the damage caused by June 17th ruling. But that plan is doomed to fail. Family Law Rule 85b-4 permits, indeed requires, that void orders be set aside. So let's say in the next 30 days, Judge Fisk comes back and removes Mata from the case. We will then immediately bring a motion asking the new judge to vacate today's order, denying Laura's post-trial motions that will open the door for the new judge to rule on those issues. Again, just like today's order never existed. Which is kind of what I said. She denied it, and it can either stick because Mata stays on, or some other judge can come in and still deny it, or a new judge can come on and say, approved. And we will know here soon. But there was nothing wrong about her doing that. It can either stay that way or not stay that way. And maybe she will sign it once that part has been, when they find out if Mata is staying on or not. Right now, it's just she's filed it, and then once she finds out if she is actually going to still be the judge, she can sign it and make it final. I don't see anything wrong with her denying this stuff. 7. Ultimately, even if Judge Fisk denies our request to disqualify Mata, that basically has zero impact on the case. We would simply appeal that issue, along with everything else. Great. Do that. Stop yapping about it and just do it. Get it over with. Put up or shut up. And I am confident the Court of Appeals would not look kindly on what has happened here. I don't think they will like what your client has done, is what I'm thinking. So I don't think they'll look too kindly on what has happened in this case either. But it may not be what you're thinking about. Thus, the Court of Appeals could still send this back for a new trial, and that would involve an automatic change of judge as a matter of right under a different rule. Rule 6, not 6.1. Good. Congratulations on you being an expert in appeals. And you must know a lot about appeals, because you seem to be very fond of them. And you know who appeals are made for? Losers. All this procedural nonsense aside, there will be a day when all the issues are resolved. One way or another, Laura is entitled to her day in court in front of a judge who is fair, unbiased, who cares about the rules, and who actually follows those rules. You have no proof that this judge has not been any of this. Just because Owen says it's true doesn't mean it's true. That day hasn't come yet, but it will. I think it has come. Come and gone. P.S. I forgot to mention one important issue that the JFC has consistently been wrong about. No, Laura does not have to post a bond to appeal. This is a common misconception, and it's 10,000% flat wrong. Has nothing to do with the issue of monetary versus non-monetary relief. A bond is only required to stop post-judgment collection efforts, but that shouldn't be an issue here. Really, because it could be gaining interest. And if you don't want the interest to start accruing, then yeah, you're going to need to. If you see anyone claiming that Laura can't appeal unless she posts a bond, please know that this that person has no clue what they are talking about. And no, Laura cannot, as a matter of law, be declared vexatious because Arizona law 123201 only allows pro se litigants to get that tag. People who are represented by counsel, like Laura, are excluded from the vexatious litigant statute. Well, good thing she has mommy and daddy to pay her bills, right? So, because otherwise she would be considered that. And then here he puts an example from Hypocrite, replying to Clayton's judges and legal vices. Great insight from Reddit. And then, of course, Gingras says, or not, with a unhappy face. Says, I think this is his only plan. As I understand, to appeal Mata's ruling, Owens would have to post bond for the amount awarded to Clayton. She apparently does not have the funds for that, so Blank's tactics is to file these motions for a new trial, which is really an argument to be made on appeal, so I expect them to go nowhere. When they get denied, he can then appeal those decisions because no bond is required to be paid by Owens for non-monetary decisions. When does the frivolous motions practice end? In my opinion, only these options. Owens is arrested and charged criminally. Gingras is sanctioned himself by the court, or Owens is declared a vexatious litigant. High bar, but she is well on her way. So you're taking one person's post from Reddit and you're attaching that to everybody in the Justice for Clayton cult, as you say. This has 9 upvotes. Not a whole lot. And maybe they are thinking about another case because different places have different rules. But if you do not want the interest to start accruing and you don't want to pay more than what has been told to pay, then you put up or shut up. She can still put up or shut up. But file your appeals. File all the motions you want. I don't think it's going to change anything. He is doing his job as her attorney to fight till the end and be a zealous advocate for Owens. Whether he's doing it to just make more money and make a joke name for himself, I don't care what his motive is behind it. Let her lawyer do all the lawyering that he wants to do. Doesn't mean it's going to change anything. And even if there is a new judge, I don't think it's going to make any difference anyways. To me, that would be crazy. Because I don't think anybody will look at this case and see it in any different way. I don't think a jury of Owens' so-called peers would see it any other way. But we will just wait and see what else comes out, because this show is not over. Okay, well, this episode in this case is over. And so we are ending with our quote of the day. The goal is justice. The method? Transparency. It is important not to confuse the goal and the method. We want to have transparency. That is why it's great to have the cameras in the court, to have things on paper available to the public as a part of our Constitution. We need transparency because that is the only way that we can learn, we can grow and be better, and we can make important changes or hold people accountable for their actions. And that is the goal of justice. That is what we want in justice. We want transparency. We want the wrong to have their actions punished, and we want the people that deserve justice to get it. And transparency is the way to it. That is it for me today. Please hit that subscribe button, share it if you want, and I will see you guys next time. Bye, y'all.